It seems to be a universal concern that if an individual holds property, they are concerned about where this property ends up when they die. And certainly in the Anglo-Saxon period, in England we see evidence of people trying to direct where their property went on death, whether this be movables, chattels, or land. We also see attempts to do the same after the conquest in Anglo-Norman England. We see people making grants of land, post-obit grants of land, so grants which are affected on their death. However, later in the 12th century, the English common law took the English law, which was emerging into the common law, took a stance against post-obit gifts, and the technical legal reason for this was that to make a valid grant of land, you have to transfer seisin, you have to undertake the livery of seisin, which means transferring something symbolically from one person to another, which made the grant valid. And of course, if someone has just died, they can't do that. They can't do many things. So these grants were left incomplete and could be challenged by the heir if they were designed to direct land away from the normal succession of inheritance. So it became a rule of the common law that land could not be disposed of by will, and this lasted until the Statute of Wills in 1540, which allowed it to be possible in some circumstances. But wills could be used to make bequests of movables.
Yeah. Wills concerning movable goods were actually part of the jurisdiction of the church courts. Michael Sheehan described the English will as, he's called it an interesting example of a legal instrument born of the meeting of three great cultural strains in medieval Europe: the medieval Christian practice of bequeathing property in alms, the Germanic family custom regarding property ownership, and kind of legal notions in Roman law. This original notion of wanting to give alms was very quickly expanded to kind of provide a testamentary capacity in which you would bequeath items to family members, people in your household, things like that, and it's not just regarding ecclesiastical property. So in the 11th and 12th centuries, the church's involvement in wills and testaments primarily concerned the protection of property bequeathed to the church for pious purposes. That's how they initially got involved. If someone left a part of their estate to the church, it was the bishop who was supposed to make sure the alms and bequests were properly administered. But by the end of the 12th century, the bishop's role had expanded to include the hearing of testamentary disputes and the administration of executors. Now, in the law book called Glanville, it states that if anyone has anything to say against the testament, for example, that it was not properly executed or that the chattel claimed was not left as a legacy, as it was alleged, then the plea about this was to be heard in the ecclesiastical courts. Because pleas concerning testaments ought to be dealt with before an ecclesiastical judge and determined according to the course of law by the evidence of those who were present at the making of the testament. Now, it's likely that if a person died without confession, it was the bishop's responsibility to distribute the goods for the remedy of the deceased's soul, which might be in jeopardy if they had died without this confession. And wills were composed in the presence of witnesses, as noted in the text from Glanville. And these usually commended the testator's soul to God, named a place of burial, listed the bequests, and named the executors. The document itself was often written by a clerk and sealed by the testator and the witnesses as well. Mm-hmm. Wills then concerned bequests, gifts to individuals, and gifts to institutions, mainly religious and academic institutions. And they did not specifically name heirs, because you can't do that, only God can make an heir. But they listed legatees who were to receive money, rents, clothing, animals, whatever goods you might have, any movable chattels, as well as arranging for the payment and receipt of debts.
There's an interesting coda to the common law's traditional aversion to the disposition of land by will and its focus on bequests of chattels. There is some evidence to suggest that burgage plots, so land held in towns, by burgage tenure could be deposited by will. Why this is, we're not entirely sure, but we certainly see charters of exemption from certain inheritance actions, such as mort ancestor, which would work to undercut the legal power of any testamentary disposition of land, and the legal treatise as Bracton does also give some indication that burgage plots could be left by will. And there's an interesting coda to the common law's focus on the bequest of chattels and the prohibition of dispositions of land. There is some evidence that at least certain burgage plots, land held by burgage tenure, could be left to an individual in a will, probably because merchants holding this land were used to sort of commercial transactions and used to used to exchange, and wanted to ensure that they had tighter control over where their property went, perhaps than other landholders.
Yeah, the line between what is movable and immovable goods seems quite blurry in some places. Rents in particular often include what would seem to be more a bequest of land than the actual rents pertaining to it. So you can see there's a bit of leeway perhaps.
Can we just keep that going for 1 second while I
Of course.
change that?